Good afternoon, everybody. Good to see so many of you here. This is the first of an afternoon of talks about business protection in a variety of aspects. And because everyone will be feeling a little snoozy after lunch, we thought we would start with the most left field of those four. So we aren't going to be talking about particularly well-known issues in relation to employee competition, but we are going to talk about competition law and why not. And if you're going to do it, why not do it straight after lunch? So Alex and I have had a number of cases where we've increasingly had to delve into the world of competition law. One of the great things about this job is that you're always learning something, and it's never too late to learn something completely new. And almost immediately afterwards, share it with a room full of 100 instructing solicitors. So we want to look at the role of competition authorities in business protection litigation. And let's just think about how that fits together. The world of business protection, particularly post-termination restrictions, is one of those areas where you don't always get what you bargain for, do you? You write a contract, you agree to a contract, somebody down the line is going to tell you that that's all a load of rubbish and it's not enforceable. That's the way, the pattern, the way that these things go. And there are a number of ways that we might find that our contract is not enforceable. One is because the courts might tell us, through the application of restraint of trade principles, that it's unenforceable. Another is that legislators might tell us that it's unenforceable by some sort of statutory regulation. And obviously that's something that's been talked about quite a lot here. The Conservative government's interest in banning non-competes is probably no more than historical and academic interest at the moment. Who knows after the 4th or 5th of July what will happen to that particular legislative change. We're not really talking about that now, but just to note, that's another area that might control what's happening to our contracts. What we want to talk about is the third area, which is where competition authorities may intervene to restrict the use of non-competes or other types of post-termination restrictions, because that has been an area of increasing interest in the US, increasing interest in EU jurisdictions and in this country. So what we're going to do for the next half an hour or so is give you a bit of an update about what's been happening principally in the US and in the UK with competition regulators, explain some of the legal background and explain some of the consequences for us when we're dealing with business protection disputes. So without further ado, I'm going to hand over to Alex, who's going to start off with the US perspective. Literally going to hand over the baton to Alex.
Thanks, Gavin. On the 23rd of April this year, the US Federal Trade Commission, FTC, issued a final rule that bans non-compete clauses between workers and employers. It ruled that such clauses were, quotes, unfair methods of competition and hence unlawful under sections 5 and 6G of the FTC Act. This was a highly anticipated ruling and the result of a narrow 3-2 majority vote, with the 5 commissioners of the FTC voting along party lines. It was and remains an explosive decision. The final rule itself and the supporting text runs to about 520 pages, and it's got detailed and stimulating analysis, including of complex market economics. But this is a talk about competition, and I'm mindful that my greatest competition at this stage is probably the clamour for that quiet postprandial snooze that Gavin mentioned a moment ago. So what I'm going to do is give you an abridged summary of what the rule says and what its impact is, and then turn to what the equivalent position is in the UK and how all of those things might affect us. First then, what is the scope of the FTC final rule? Well, distilled to its essence, it says 3 things. Number 1, existing non-competes are no longer enforceable. Number 2, new non-competes are not enforceable. And number 3, employers must provide workers with notice that non-competes are no longer enforceable. The final rule defines non-compete clause broadly to include any term or condition that prohibits, penalises, or functions to prevent a worker from seeking or accepting work or operating a business in the US after the conclusion of employment. And the ban applies to all workers. Worker is expansively defined and will likely encompass employees, independent contractors, interns, volunteers, and sole proprietors or owners. There are a number of carve-outs and jurisdictional limits on the final notice. I'll address only the most significant, which is this. For existing but not new non-compete clauses, the final rule distinguishes between mere, quotes, workers and the concept of the senior executive. And it permits existing non-competes to remain in effect for, quote, senior executives, but for all other workers, non-competes are immediately unenforceable from the date that the rule becomes effective. Obviously, that begs the question, what is a senior executive? And that is the $151,000 question, because it's got a two-part definition. The first part is that it's somebody who was in a, quote, policy-making position. And the second part is that they must have received a total annual compensation of at least $151,164 in the preceding year. Now, it appears likely to mean, or intended to mean, something similar to whether an employee in this jurisdiction is a fiduciary. You look at the seniority of their role, you look at their responsibility, you look at their decision-making capabilities. So just as that test is rather uncertain in this jurisdiction, one can expect a huge amount of litigation in the US as to whether someone was or was not in a policy-making position. The rule takes effect 120 days after the publication in the Federal Register, so it's slated to be operational on the 4th of September of this year, but as we'll see in a minute, that's subject to legal challenge. What's the scope geographically of the final rule? Well, the definition of non-compete clause is expressly limited to terms or conditions that prevent workers from seeking or accepting work in the US or operating a business in the US. It doesn't apply to non-competes that restrict work or starting a business outside the US. It could apply, importantly for our purposes, to overseas employers if the non-compete purports to restrict work within the US and if the reviewing court applies US law. There are two important limitations. First, garden leave clauses are seemingly beyond the scope of the final rule. That's because during the period of the garden leave, the employee remains employed by the employer, so any restriction on their activity can't, strictly speaking, be a restriction on post-employment activity. And the second important limitation is that clauses to protect confidential information are also expressly not caught by the scope of the final rule, and indeed the protection of confidential information, clauses to that effect, are one of the two alternatives to non-competes that the FTC suggests can be implemented instead of a non-compete in order to protect the legitimate interests of employers. What then are the implications of the final rule? Well, the short answer is hugely numerous, but I'll just give a few key points. First, for the FTC, I said the rule was passed by a 3-2 majority. The two Republican commissioners who were opposed to it were opposed not just on the principle of the rule, but whether the FTC had authority to make the rule in the first place. So it's unsurprising that within 24 hours of the rule being issued, the US Chamber of Commerce and various other interested parties had filed a suit in the US District Court for the Eastern District of Texas, seeking a declaratory judgment, an injunction that prevents the rule ever being implemented. And since then, there have been many similar applications issued seeking similar results. The general view of commentators in the US seems to be that it's likely that the implementation of the rule will at the very least be delayed, and there's a real chance that it'll be found to be invalid or have to be substantially reframed. But there's a period of great uncertainty until the courts decide what's going to happen with it. And obviously the prudent employer must proceed on the assumption that the rule will be implemented, at least in some form. One thought about an implication for employers. Now, assuming that no injunction is issued which prevents the rule from taking effect, employers need to be mindful of the retroactive effect of the final rule. So as I said earlier, whilst non-competes entered into after the effective date will be unenforceable for all workers, existing non-competes are only unenforceable for workers who aren't senior executives. So there's something of an opportunity for employers. There's a short window of time for them to enter into enforceable non-competes with senior executives so as to evade the consequences of the final rule. Counterintuitively then, the introduction of the final rule may result in more non-competes with senior executives rather than fewer, at least in the immediate term. And it's significant that there are no penalties in the rule which are attached to employers from adopting that strategy so as to enter into non-competes in very short order over the coming 3 to 4 months. For employees, the impact is probably positive, at least in the immediate term, for obvious reasons. Two specific observations of many potential observations. First, query whether the impact of this rule even being issued, whether or not it's actually brought into effect, is that international senior executives will be emboldened and push harder against the imposition of non-competes when they're negotiating their covenants. Will they take the point that whether or not they're going to be employed in the US, there's increasing evidence that a non-compete of, say, 12 or 24 months is just no longer reasonable or commercially acceptable? I think we can expect more discussions about that point. Second, what are the implications on the global search for talent? Are employers more likely to be attracted by the recruitment of an employee from the US to be employed in the US, who's likely to be able to start work without the burden of a non-compete? Or are employers more likely to be attracted by recruitment from outside of the US, somebody who's going to be subject to a contract with, for example, an English law jurisdiction clause, on the basis that they'll then have better prospects of being able to impose binding non-competes on that individual and thereby protect their business? In either case, advisors in respect of international organisations and employees will need to be mindful of the impact of the FTC rule when drafting and advising on service and related agreements. So much then for the position in the States. Let's bring matters into this jurisdiction and think about the equivalent body in this jurisdiction, which is the CMA, the Competition and Markets Authority. The CMA is a non-ministerial department and, at least historically, a less political animal than its US equivalent. What really is the relevance of the CMA to employment lawyers, and why are we talking to you about it? I want to walk you through a chronology of publications that have been announced by the CMA in order to show what we see as being a shifting tide and a change in the direction of interest of the CMA. First point is the 26th of February 2020, which was the cheating or competing campaign introduced by the CMA. This was designed to crack down on illegal cartels, not in the labour market, but more widely and specifically on the construction industry. It appears to have been triggered by a quite remarkable result of a survey of the construction industry, which found that 29% of those questioned said that they thought it was, quote, okay to attend meetings with competitors in order to agree prices with each other. So an easy starting position for the CMA, and an odd choice if they didn't take steps to try to redress those problems. Moving forwards from there, we have the annual plan for 2023 to 2024. And we can see there that the focus begins to shift, point 2 of the slide, to labour markets. There's the first mention in that slide to labour markets. It said, at a time when public and household finances are under particular pressure, we'll also continue to clamp down on collusive behaviour, for example, in agreements that seek to interfere in labour markets. CMA has then since emphasised the risk of criminal sanction It's introduced a leniency regime to encourage self-reporting. There are rewards to whistleblowers. And at the moment, there are no fewer than 3 live investigations in respect of labour market potential non-compliance. Moving forward from there to 2023, we've got a CMA guide in February, which is published on its website. And for an institution that's not known for the brevity of its output, the first striking point is the concision of this so-called advice note. It runs to about 2 pages, and it's got virtually no detail of any value. But there is some specific comment on the potential negative consequences of anti-competitive agreements in labour markets, including the first 3 bullet points on the slide. And from the final 3 bullet points on the slide, you'll note in particular the second bullet point, actions businesses can take don't agree with a competitor not to approach or hire each other's employees, a significant recommendation about which Gavin will be speaking in a minute. Whereas the paper we've just looked at was very light on detail, the document that's now referred to on your screen is the opposite. It's a CMA research report on competition and market power in UK labour market. It's dated the 25th of January of this year. It's actually a really interesting and a detailed document which sets out a data-driven rationale for the CMA's more intensive scrutiny of anti-competitive agreements in the labour market. It's quite a persuasive read. There are some interesting findings for all of us as employment lawyers, quite aside from the impact of the CMA's conclusions as a result of the paper. So first question, and I won't ask you to guess aloud, but the percentage of firms which use restrictive covenants was found to be 15%. Second percentage I found quite remarkable. The percentage of workers in this jurisdiction that are covered by non-compete clauses, 26%. And the third fact or statistic, around 24% of surveyed workers with a non-compete clause believe it's made it harder for them to leave their current employer to join a competitor. There's an important point, I think the most important point that emerges from this paper, which is as follows. It seems to me that the main driver for the new scrutiny that the CMA is imposing on labour markets isn't so much the sorts of senior executives and banks who feature in the authorities and who keep most of us clothed and shod. Rather, it's relatively low-paid employees in, for example, the fast food or the care services, whose contracts contain non-compete covenants as a matter of course. Now, those, of course, are very likely to be perfectly unenforceable, but nobody ever has the courage or the resources to test them. And that's a point of real concern for the CMA, and it was also a point of concern for the FTC when you look in the detailed rationale as to why they introduced the final rule. So where does all this leave us? I've got 3 concluding marks to leave you with before I pass over to Gavin. The first point is it's interesting that regulators have succeeded, or nearly succeeded, where legislators have failed. There have been extensive debates in the US and here about legislative solutions to problems that have been caused by non-compete restrictions. But in the current highly partisan environment, there's neither sufficient consensus nor, frankly, parliamentary time to actually get anything done. So regulators have the advantage of being more dynamic and perhaps also the advantage of being less immediately accountable to an electorate. So they just move on and pass these notices and get things done. Second point is this: the focus of the CMA at the moment is limited to agreements or arrangements between employers, as we'll see from Gavin's analysis in a minute. But there's just the merest hint about the possibility of the CMA extending its reach yet further so as to police non-competition covenants within contracts of employment, as the FTC has done in the USA by the final rule. So if you look at the speech which accompanied the CMA research report that we looked at a minute ago, there's various comments that are made by the CEO of the CMA. And one of them is this: it said that that non-compete clauses are not, quote, generally within the scope of their jurisdiction. But then there's this kicker, which I'll read aloud. But as the report concerns, we've seen significant shifts in labour markets and the nature of employment, with a rise in prevalence of self-employed people, especially in the gig economy. These developments potentially give rise to new questions for competition authorities about how and when such activity is or should be caught by competition rules. There's no more said about that, and certainly there's no identification as to what possible jurisdictional basis there could be for the CMA expanding its remit so as to encompass non-compete clauses within individual contracts of employment. But it seems to us that's one to watch. Third point is this: as Gavin alluded to earlier, although the focus of this talk has been on the US and the UK, similar noises are being made by regulators in other jurisdictions. So in the EU, in France and in Belgium, regulators are taking increasing interest in the impact of non-compete clauses on labour markets. It seems to us that regulatory activism in this area is only likely to increase. Now, with those few thoughts, I pass over to Gavin to explore in more detailed terms the implications for businesses operating in the UK.
So, thanks ever so much, Alex. What I want to think about for a few minutes is the impact of what we've heard the CMA saying on the sorts of cases that we might commonly deal with that deal with hiring of employees, often in unlawful circumstances. So we're thinking about breaches of post-termination restrictions in relation to non-poaching of employees, thinking about the sorts of issues that arrive in team move cases where a departing employee has breached their duties before leaving employment to take a bunch of people with them, and a new employer is on the scene who's been inducing those breaches and possibly committing other economic torts or breaches of confidence along the wayside. And it's worth thinking about how some of these ideas we've seen from the CMA impact on what we might think as being a typical remedy in that situation. Because typically, from an employment law perspective, one will be thinking, well, we want some sort of remedy to stop this wrongdoing new employer and its these treacherous employees. Sorry, I do a lot of claimant work on this side. We want some sort of remedy to stop the loss of blood, to stop more employees from going as a result of this unlawful action. Often a springboard injunction, happened quite commonly. Think about cases like Willis and JLT, Force and Sakama, a whole stream of cases in which one's seen these sorts of restrictions in place. But the CMA is telling us, have I gone back to the right slide? I have. Thank you. I'll just go back one.
Oh, sorry.
One more. Sorry, that's you. Thank you. So that very short notice from the CMA that Alex talked about makes clear that it very much has in its sights no poaching agreements. And let's be clear, let's start with the classic case that the CMA is concerned about there. It's concerned about cartel activity. So two or more companies get together, they say, look, let's not have a scrap about this, let's all just have hands off everybody's employees. And that the CMA says is anti-competitive because it's an impediment to other people coming into the market if a small number of players have effectively stitched up that market between them. And it's an impediment to free movement of labour for workers because they're restricted in the places that they can go. Actions that business can take, according to the CMA, is understand how competition law applies to no poaching agreements. Tempted to think, having read both pages of that document, well, why didn't you tell us what that is in this document? But they didn't, so we've got to work it out for ourselves. And let's look at the statutory underpinning of the legislative bedrock of what the CMA is dealing with and see how that applies to the sorts of scenarios that I've been talking about. And the bedrock is here on this slide. It's section 2 of the... Sorry, am I getting confused? Those slides are not synced to up.
No.
It's taken me 20 minutes to work that out. But
as ever, I'm on a frolic of my
own. On the right slide. So agreements preventing and restricting or distorting competition, section 2. There's a number of components here we need to look at. First of all, agreements between undertakings. So we're talking about a business-to-business agreement. First point, so that's not directly going to affect a non-solicitation agreement, non-poach agreement in a contract of employment, because that's not an agreement between undertakings. But 2 points. First, Alex has already sounded a note of caution that the CMA may be looking to expand its horizons in the future. But more particularly for now, although Section 2 is not going to affect a contract of employment with an individual, if you're looking at a claim against a new employer or settling a claim against a new employer for inducement of breach of contract or unlawful means conspiracy or howsoever, then when you come to try and settle those proceedings, that is an agreement between undertakings. So Section 2 is not directly impacting your claim in court, the relief that you might seek in an injunction order or in a claim for damages. The problem comes when you try and settle these disputes ahead of going to court, and the competition lawyers are saying to you, well, hang on a minute, that springboard relief that you're just agreeing in your contract looks to us to be anti-competitive. That's the problem that we've got to grapple with. There is no doubt that from some cases in the intellectual property and patents arena, that an agreement in settlement of litigation, pending or contemplated, potentially falls within the scope of Section 2. So you can't simply say, well, this is a settlement of proceedings, so we're outside the scope of the section. Second point, we are looking at agreements which may affect trade within the United Kingdom. Well, that's just a geographical jurisdictional limit. Are we talking about trade in the United Kingdom? But more materially, the third point, has as their objective or effect the prevention, restriction or distortion of competition within the United Kingdom? Well, I think traditionally we might not have thought that's not really in play for the sorts of situation that we're talking about, undoing the harm that's been caused by unlawful competitive activity. But I think looking at the mood music and the noises that have come out of the CMA in recent years, these sorts of issues that can distort the labour market seem very much to be in their radar as something that has the objective or effect of restricting or distorting competition. So an agreement that meets those elements of the definition that we've got highlighted on the screen is prohibited unless exempt, and I'll come to the possible exemptions in just a moment. I've talked a little bit about settlement agreements. Don't particularly want to say anything about burden of standard of proof, other than that, as you might expect, CMA has the burden of proving that Section 2 is made out. Any defences or exemptions, burden on the defendant to prove. Why do we care about this? Well, because the consequences are, to use the legal term, absolutely horrific if one gets this wrong. And they are essentially threefold. First, an infringing a prohibited agreement is void. So that's a situation where you don't get what you bargained for. But that is by no means the worst of it. The worst of it is Section 36 of the Competition Act, which makes it an offence to enter into an anti-competitive agreement in breach of Section 2. Potential fine of up to 10% of worldwide turnover of the agreeing business, which is punchy, I think we would all agree. Section 98, a third party who's been caused loss by an anti-competitive agreement can bring a claim to the Competition Appeal Tribunal for damages. So there's a world of pain to be had from the consequences of being in breach of Section 2. But as so often, the process may be the punishment. CMA investigations can take a very long time. They can be extremely expensive to deal with. And the publicity that comes out of being under investigation for effectively cartel anti-competitive behaviour can be extremely harmful to a business. So there's a real problem here. There's a lack of clarity, because there aren't any decisions, on scope of application of this section in the sorts of arenas that we're dealing with. And to get clarity, you're looking at a long and expensive and partly public investigation with an extremely large bill at the end of it if you get it wrong. So you can see there's a degree of hesitation entering our arena as to entering into agreements about springboard shape relief in relation to no hire of employees. What are the defences? Well, complex and not very clear, I think, is the headline that I should have put on the top of this slide. Ancillary restraint. The concept here, we're a little short on time, so I'll deal with this quickly. If you've got an agreement that is not itself anti-competitive, but there is a clause within it that does have, on the face of it, an anti-competitive effect, that may be justified and not prohibited if it's a necessary provision to make the overall agreement work. That's the ancillary restraint component. So an example, pertinent to us in the employment sphere, is on the sale of a business. The case of Reuters and BASF, an old 1970s case, sale of a business, non-compete clause within the business sale agreement designed to protect value for the vendor. That is potentially an ancillary restraint because the non-compete restriction is necessary to give effect to what is not an anti-competitive agreement, the sale of the business. Whether that works in the situation of settlement of a claim for in a team move case, query. The exemption, I did say I was going to come back to this, we find in section 9.1. You can an agreement can be exempt if it has certain, I've got it on the slide, but we characterise this in a way that there are certain positive economic benefits and an absence of certain other characteristics. I find that quite complex, and I find it very uncertain to advise with any confidence as to whether a particular agreement falls within the scope of that. So we don't get a great deal of comfort as to exemption. Where does any of this take us? I hear you all ask. Well, it's difficult to draw any clear conclusions. This is a session that's thrown up more questions than answers. I'm seeing, Alex and I have certainly seen in our work over the last year or so, an increasing concern to look at settlement of business protection disputes from a competition law perspective. Competition lawyers, certainly the ones that I've been dealing with, or that might just be the crowd I mix in, have been cautious on these issues, which I think is affecting strategy as to settlement. And let's face it, you should never go into any dispute without a clear sense of what your exit strategy is, what your settlement strategy is going to be. So if these issues are affecting settlement strategy, that really means it's affecting strategy full stop, your day one strategy as to what you do. And I think it's hanging a question mark over relief that we might seek in team move cases where, in the cases where you've lost everybody, and it's too late to do anything about it, well, that's not a difference. But where one might have thought about some sort of restraint to stop the losses, I think that one needs to think more carefully and get some specialist advice rather than just what I've told you this afternoon. There are no decisions that give us any clear answer on this, but it's certainly something that we need to put our heads together with our competition law colleagues. As Alex said, this is an easier route to get into the world of business protection and limitations on non-competes and other restrictions than through a legislative mechanism. So for all the talk of the ban on non-competes, this I think is where the action's at. So watch this space. That's it from us. Thank you very much. Back to you, Nick.
Thank you very much.